A company administration is a formal insolvency process, but first and foremost a means to try and rescue a business. It can take various different forms depending upon the independent circumstances that a business is currently experiencing. It could be utilised as a means to facilitate a sale of the business and assets. It could be used as a way to rescue the business and limited company itself as a going concern, or it could be utilised as a means to formally wind down the business and close the doors to achieve the best outcome for creditors. A company may be placed into administration in one of three ways. The first being via the company's directors or shareholders. The second via the company's qualifying floating charge holder if there's one present. Or the third via an application to court. That application to court can be made by a creditor or by the company's directors and shareholders. The key thing with all of those routes in is that it requires the involvement of the court in each scenario. A business should consider entering administration if it's hitting a point of distress. Firstly, it should be considering any additional advice it should be seeking from its financial advisors or accountants, but most importantly, where that distress is present, they should then be seeking the advice of an insolvency practitioner. That insolvency practitioner will review the financial circumstances surrounding the company's current position and make that assessment as to whether administration is the appropriate route. The main benefit of administration to a struggling business is the legal protection that it can provide to that company. Where a company enters administration, it obtains what's known as a moratorium, which provides legal protection for the company against any parties taking any action. What this can do is provide breathing space for a company to allow sufficient time for a rescue or for the business and assets to be marketed for sale to ensure that the best outcome is achieved for creditors. That moratorium period can take two forms. In administration, where there's what's known as a qualifying floating charge holder present, there's the need to issue what's known as a notice of intention to appoint an administrator before entering that administration process. Where a notice of intention to appoint an administrator is issued, the company then benefits from what's known as an interim moratorium period, which can last for up to 10 business days. Once a company enters administration, then the full moratorium comes into effect, and that lasts for the full period of the administration. The main difference between administration and other insolvency procedures is that administration, first and foremost, is a means to attempt to rescue a company. If that rescue isn't possible, then the legal protection that the moratorium provides can often result in a better outcome for creditors as a whole than would have been available if the company had entered liquidation straight away. As administration is a formal insolvency process, the impact that it has on creditors, employees and shareholders is very much the same as other processes. The key difference being, hopefully an administration process can achieve a better outcome for those parties. Specifically with employees, the administration process doesn't automatically terminate contracts of employment. So where there is potential to rescue the business, then employees' contracts of employment could be transferred to a purchasing entity, or they may in fact just remain in place whilst the business is traded through administration, and if that trading period is successful and the company exits administration, then employees will just continue as they have before. In the circumstances where it's necessary to wind the business down and cease trading as part of the administration process, unfortunately it will be necessary to look at making redundancies as part of that administration. In respect of shareholders, shareholders may obtain some form of return if the administration process is successful enough and there is the potential for that company to be handed back to the directors. But in a lot of circumstances, the outcome for shareholders is they're not going to be experiencing any form of return in that process. The primary goal of placing a company into administration is to seek a rescue of that company. However, in circumstances where the limited company itself cannot be rescued, then you would seek to achieve a better outcome for creditors as a whole than would have been possible if the company had just gone straight into liquidation. In some instances, this can take the form of a sale of the business and assets as part of the process once the administrator is appointed This could either be a sale that is negotiated prior to the appointment of the administrators, known as a pre-pack sale, or a sale that is achieved once the administrator is in office and seeking to market the business and assets at that point. The administration process allows time for a business to seek rescue or restructure by utilising the moratorium period that becomes available. Where there's the presence of a qualifying floating charge holder and that interim moratorium period is available prior to the appointment of administrators, that period can be utilised to market the business for sale. If a purchaser is found in that period, the sale is then negotiated, sale documentation agreed, and then the sale can be completed immediately upon the appointment of the administrators. That provides continuity of business and employment for the employees. That process is known as a pre-pack sale or pre-packaged sale of business and assets. Where that's not achievable, the full moratorium upon the appointment of the administrators again provides that legal protection and allows the administrators to seek a buyer for the business and assets where that's appropriate, or in some instances it allows the administrators to trade the business for a period of time. The administrators have to be happy that the business is viable in that period and that trading in that period is not to the detriment of creditors. However, that protected trading period can sometimes offer what is needed in terms of time and breathing space to allow the company to reach a more profitable position or even seek a buyer. When an administrator is appointed, they are an officer of the court. So by its pure nature, the court is heavily involved in an administration process. There's various stages where the court is reported to and consulted during administration. The very first point of this is during the appointment process itself, where documentation is presented to court for it to be stamped by them and approved. There are other points within the administration process where the court is reported to. This is following their appointment, upon the proposals of an administrator being presented, but also there are other functions where the court may act. The court may be approached by the administrator themselves for direction in respect of certain decisions. The court are also approached when the administrator is seeking to exit an administration or even seeking an extension of the administration in some circumstances. But additionally, the court could become involved where there are issues in respect of the administrator themselves and the creditors wish to challenge actions or decisions that an administrator has made. A company would ordinarily be entering administration because that is the best process for it to go into in the first instance. That does not always mean that that company will not then end up in liquidation. In certain circumstances, an administration process will exit via a liquidation process. This is generally good news for the creditors and in particular unsecured creditors, because unsecured creditors can only be distributed to through a liquidation process where that distribution does not form what's known as the prescribed part fund. In other circumstances where an administration is complete and there are not funds to distribute to unsecured creditors, then the administration may just formally come to an end and the company be dissolved at the end of it. Other circumstances for an exit of an administration may be that the company is purely handed back to the directors because the company is traded out of the position, or that there has been a successful proposal for a CVA approved as part of that administration process, and then the company is handed back to the control of the directors for them to continue trading through that CVA. Where a company enters administration, the appointed insolvency practitioner or administrator must be satisfied that one of three statutory objectives may be achieved. These objectives or purposes are the rescue of the business as a going concern, achieving a better outcome for creditors as a whole than would have been achieved if the company hadn't first entered administration, or achieving a distribution to one or more secured or preferential creditors. Those objectives are achievable in a number of different ways. The rescue of the business as a going concern purely means that that business is able to continue trading moving forwards. That may be that the business and the company is handed back to the control of creditors as a result of a successful trading period in the administration. Or that successful trading period has enabled the administrator to propose a CVA to its creditors. That CVA has been approved, and again, control then passes back to the directors of the company to trade moving forward. Achieving a better outcome for creditors overall, had the company not been first placed into administration, could be achieved through a sale of the business and assets of the company, whether that's through a pre-pack sale or a sale of the business and assets that have been negotiated by the administrator once appointed. And the third objective can be achieved by realising the company's assets to enable a distribution to be made to those secured or preferential creditors. There are certain circumstances in an administration where enhanced asset realisations are available that wouldn't have been available if the company had entered liquidation straight away. And that is due to the protection that is given to the administrator and the company through that moratorium period.